Good afternoon, everybody. Thank you for joining us today for our annual False Claims Act review, where we will be covering False Claims Act enforcement and compliance updates for government contractors, what to watch in 2026. I'm Jackie Unger, and I'm joined today by my partner, Todd Reinecker, chair of our Litigation and Dispute Resolution Practice Group.
Good afternoon.
Can we move to the next slide? Thank you. So a little bit of background about us. As I said, I'm Jackie Unger. I'm the chair of PilieroMazza's Government Contracts Practice Group, as well as the co-chair of the firm's False Claims Act group. In my practice, I help contractors navigate doing business with the federal government, which includes advising on disputes with the government, counseling on FAR and small business regulatory compliance issues, litigating bid protests and size and status protests, and of course, helping contractors with all stages of government investigations, including dealing with False Claims Act issues. And with that, I'll turn it over to Todd to introduce himself.
Thanks, Jackie. As Jackie indicated, I'm Todd Reinecker. I chair our Litigation and Dispute Resolution Group, very deliberately named Litigation and Dispute Resolution, in addition to handling litigation matters of all stripes and sizes and various subject matters. We very much handle risk assessment, risk analysis, how to avoid litigation altogether. And we also have a very robust government or False Claims Act practice that works very closely with Jackie and her team. So pleasure to be with you all today. Next slide.
So here we've got a little bit of information about our firm if you're not already familiar with PilieroMazza. In addition to assisting in all aspects of government contracts, our firm also assists clients in the areas of litigation and dispute resolution, as you just heard, and also construction, business and transactions, and labor and employment. If you're interested in staying up to date on recent developments impacting government contractors, as well as commercial businesses generally, I recommend you sign up for our newsletters and our blogs. You can do that by scanning the QR code that we have on the screen here, or you could just visit our website at PilieroMazza.com. And then, of course, before we jump in, I just want to take a moment to remind everybody, give a little legal disclaimer that this webinar is for informational purposes only, and nothing that we say today is intended as legal advice for your particular circumstances. But that said, if you do have any follow-up questions about your particular situation, feel free to reach out to Todd or me afterwards. We'd be happy to talk to you about your situation. You can also provide any questions that you have. We have a question box and a chat box if you're having any issues. We'll try to address those questions as we have time during the webinar today. So with that, we're going to jump into an overview of what we're going to be covering today. We'll have a little False Claims Act, very high-level primer, just to remind everybody about what the False Claims Act is and how it works. And then we'll get into DOJ's annual report for fiscal year 2025, as well as enforcement trends that we've seen in fiscal year 2025 and continuing into 2026. That'll cover the rise in FCA enforcement, procurement, integrity and fraud issues, cybersecurity, pandemic era funds, trade, tariffs and customs, small business fraud, and DEI, the main areas that we're seeing. We'll also talk a little bit about the Administrative False Claims Act, current litigation relating to qui tam constitutionality, and then talking about ways that government contractors can protect themselves from FCA liability. So with that, we can get started with our brief primer on the False Claims Act. So at a high level, the False Claims Act is a statute that imposes liability on anyone who submits a claim to the federal government that they know or should know is false. The False Claims Act was passed during the Civil War, so it's been around a long time, in response to contractor fraud at that time. That sort of fraud involved contractors selling the Army faulty guns and ammunition or sick horses, things like that, that impacted their ability in the Civil War. Since then, it's been significantly expanded, and now it's used as the primary vehicle for the government to recover money obtained or withheld by government contractors, as well as grant recipients through misrepresentation. So there are a number of elements that are required to establish liability under the False Claims Act. First, there needs to be a submission of a false claim. A claim is a request for money or property, like an invoice or an obligation to pay the government. To be false, that claim of entitlement to the funds must be incorrect, unlawful, unjustified, or supported by a misrepresentation. But not all incorrect claims rise to the level of a violation. A critical element of FCA liability is the knowledge or scienter element. That means that the false claim must be submitted with knowledge of the claim's falsity. And knowledge in this context means actual knowledge of the falsity or reckless disregard for the truth or falsity of the claim or deliberate indifference as to the truth or falsity of the claim. So that means that liability can be imposed not just where there's intentional fraud, but where there's reckless behavior, which is kind of closer to gross negligence, or deliberate indifference, which is kind of like when you stick your head in the ground like an ostrich, purposefully ignoring red flags, which might, bring to your awareness potential wrongdoing. You're basically just ignoring that altogether. Finally, for a false claim to result in liability, the false statement must be material to the government's decision to pay, meaning that it has a natural tendency to influence the decision maker, the government agency decision maker who's deciding whether to pay out the claim. So basically, that means that the false or inaccurate statements, if they wouldn't impact the government's decision to pay the claim, then there wouldn't be any liability under the FCA. So these knowledge and materiality elements, they're really critical to differentiating between simple mistakes that contractors might make or garden variety of contract breaches and an FCA violation. The FCA is not supposed to be used to go after those lower level mistakes or basic contract breaches, although we do see situations where, in our view, it looks like we're dealing with a contract breach. In the government's view, they see it as an FCA violation. And a lot of that comes to figuring out where you fall on that scienter or knowledge requirement of whether there's reckless disregard or something more there. Okay, then the next slide, please. So I wanted to go through a few examples of common types of FCA violations. The most straightforward situation, or specifically for false claims, the most straightforward situation is where the government is overcharged because the invoice itself is incorrect. So an example of this would be where the contractor bills for services that weren't provided. For instance, billing for 400 hours when you've only worked for 40 hours, or where the invoice correctly reflects 40 hours of work, but maybe charges the wrong rates for that work. So on its face there, the invoice is incorrect. Next, as we have here, is the reverse false claim situation. So underpaying or failing to reimburse the government. So this is where the contractor is already in possession of the funds, but the government is entitled to those funds, and it fails to return the money or the property to the government. So this would be like where the contractor is aware that the government overpaid, but fails to return that overpayment. And we've also seen this type of case pop up with respect to the PPP program, where a contractor might receive forgiveness for a PPP loan that they've received, which they weren't entitled to. Okay, next we've got FCA liability can arise from making false representations in conjunction with a request for payment. So in this situation, the invoice itself might be accurate. For instance, you bill for 40 hours of work and you actually perform that 40 hours of work, but the invoice is accompanied by a statement of record that's false, and that induces the government to pay the claim. So this often occurs where there's some certification that's required to go along with the invoice. This can be an express certification that all contract requirements have been met in order for the government to approve the invoice, or that subcontractors have been fully paid, for instance. It really depends on the language of the contract and the invoice as to what representations are actually required and which ones will actually influence payment by the government. There can also be liability for implied rather than express certifications. So even if there's no written certification, courts have held that the submission of an invoice by itself carries with it an implied certification that the contractor is in compliance with material conditions for payment. This means that if the contractor knows its performance has violated statutory, regulatory, or contractual requirements in some way, but they submit the invoice regardless, that invoice submission can constitute a false claim. Next on our list here, there can be liability for fraudulent inducement, where the contractor fraudulently induces the government to enter a contract through false statements or fraudulent conduct. So for instance, fraudulent inducement can exist where a company misrepresents that it's a small business, or if it misrepresents its socioeconomic status in order to get a set-aside contract, but it doesn't actually have that eligibility, or if there's a material misrepresentation in its proposal. And when that occurs, all the claims for payment submitted to the government under the contract are considered false because they're tainted by the initial misrepresentation that's used to obtain that contract. So that can result in very hefty damages and penalties there. And then finally, the FCA provides for liability for conspiracy, so conspiring with others to do any of the above that we've talked about to submit a false claims in those ways. Okay, so we can go to the next slide, please. All right, so how do False Claims Act matters come about? They can take shape through two routes. They can be government initiated, or they can be initiated through qui tam matters, through whistleblower. So government initiated matters typically arise out of an investigation, often by the agency office of the Inspector General or by DOJ, or by a complaint to a government whistleblower hotline. In those cases, the company or individual being investigated usually will receive a subpoena or a civil investigative demand from a government agency. And then if it proceeds to litigation, the United States will be the plaintiff, and they'll pursue the FCA violation and damages and penalties. As we have here, the government can pursue treble damages plus penalties, which are roughly $14,000 to $29,000 per violation. So that's every single false claim. So if you're making the same mistakes across a number of years and you're submitting invoices every month that relates to that, you can see each one of those has this penalty attached to it. And those penalties can add up very quickly to be very hefty. Even if the government's damages are low, the penalties, can be obviously very problematic. So then the FCA also establishes a private right for a whistleblower, who is called a relator, to file a qui tam matter on behalf of the US. Whistleblowers are often former employees or competitors or some other individual with inside knowledge about the defendant's actions. And when there's a qui tam action, the relator files a lawsuit under seal, so the defendant doesn't know about it right away, and the government has a chance to investigate the allegations and determine whether to intervene and take over the case or not. If they decline to intervene, the relator can then still proceed with the case. And then a notable point here is that qui tam relators are entitled to between 15 and 30% of total damages recovered by the federal government. So they're highly motivated to come forward with allegations and to proceed even where the government declines to intervene. And then lastly here, I wanted to touch on the statute of limitations. The FCA requires that a case be filed within 6 years from the time the alleged fraud was committed, but that period can be extended to 3 years from when the government official charged with investigating the fraud, which would normally be DOJ or an OIG, when they knew or should have known about the occurrence of the fraud. But in any case, the period can't extend more than 10 years from when the alleged fraud occurred. So that was a lot of information on our brief background of the FCA. And from there, we're going to jump forward into DOJ's annual report, and I'll hand it over to Todd to help us there. If we can move to the next slide, please. There we go.
Thanks, Jackie. All right, let's look at some numbers. So DOJ released its annual fraud statistics report on January of this year. That report details settlements and judgments obtained under the FCA and various statistics regarding FCA enforcement priorities, which shift from administration to administration, generally speaking. And we'll get into that in more detail later in the presentation here. So what are the numbers telling us? Well, in fiscal year 2025, FCA recoveries totaled just under $6.9 billion. That's the highest amount since the Department of Justice began formally tracking FCA statistics. That alone signals how aggressive and sustained enforcement remains. But what's equally important is the trend line here. We've seen steady and significant increases in new FCA matters. In fiscal year 2023, the DOJ reported 1,218 matters. In fiscal year 2024, that rose to 1,402. And in fiscal year 2025, that rose again to 1,698. Again, an all-time record. So that's not a one-year spike, it's an acceleration. Of those 1,698 new matters, 1,297 were filed by whistleblowers, again, key TAM actions, and that itself was a record. Government-initiated cases accounted for 401 matters, which is also substantial and also very much an indication of what an enforcement priority FCA matters are. Financially speaking, key TAM recoveries continue to drive the majority of the impact here. 5.3 billion of that, just shy of 6.9 billion, came from relator-initiated matters. 1.5 billion came from non-key TAM government-initiated recoveries, and the relator's share alone totaled 330 million. So, what are the takeaways for contractors? Well, the takeaway is that whistleblower-driven enforcement still remains the primary engine for FCA recoveries. For government contractors, this reinforces the importance of robust compliance programs and proactive risk management, because relator-initiated matters are both frequent and, as the results indicate, or the numbers indicate, financially significant. Turn to the next slide, please. So let's break down a little further the recovery dollars and where they're actually coming from. Unsurprisingly, I'm sure to many on the call, healthcare fraud continues to drive the vast majority of FCA recoveries, about 5.7 billion of the total. Healthcare has historically dominated FCA enforcement, and that trend certainly continues and has continued throughout fiscal year 2025. For government contractors outside the healthcare space, the key number is Department of Defense recoveries, and that's approximately 634 million. Of that amount, 534 million came from key TAM matters, meaning whistleblowers were responsible for the bulk of DoD-related recoveries. Recoveries involving other agencies totaled roughly 533 million. So while healthcare continues to lead in total dollars, enforcement is by no means limited to that sector. Defense contractors and contractors generally doing business with civilian agencies are still very much part of the enforcement landscape. FCA risk is not evenly distributed, but it is broadly present across federal contracting. So if we could go next slide, please. So some key takeaways. What we're seeing is a clear pipeline effect. As the number of key TAM filings and overall False Claims Act matters continue to rise, it's reasonable for us to expect that settlements and judgments are going to increase as well. These cases don't resolve immediately, very far from. In fact, they're rarely resolved in the same year that they're initiated. And candidly, the timeline ranges from long to very long. I mean, it can be anywhere from 3 to, at the far end of the spectrum, 12, 13, 14 years in some instances. These things take a long time to sort of mature on the vine for a variety of reasons. So what you're looking at is a lagging financial impact. The matters that are being filed today and that will be filed this year are likely going to drive recoveries several years down the line. As the inventory of open cases grows, we should expect the total financial recoveries to also increase over time. Not necessarily because enforcement is becoming more aggressive in any single year, but because the pipeline itself is expanding. And one of the reasons why it's expanding is the incentive structure that is in place here. Jackie spoke to that a moment ago, but whistleblowers or relators are entitled to recover between 15 and 30% of the government's recovery, plus their own attorney's fees. And that's a very meaningful financial incentive for relators and relators counsel alike. This structure continues to encourage new filings, particularly in environments where enforcement recoveries remain strong. Healthcare is the most notable example, but it's by no means limited to healthcare. So given that framework, we do expect relator-initiated matters to continue increasing, which in turn will sustain the cycle of filings and investigations and eventual settlements. Overall, the trend suggests continued growth, both in the volume, the number of cases, and the financial impact over the short, medium, and long terms. You can go to the next slide. So key enforcement issues in procurement integrity. I want to shift a little bit from the numbers to the risks that most often trigger FCA exposure in various spaces. And we'll start with the procurement space. There are three recurring themes that we continue to see, and we have some case examples there. They're up on the slides. First, false or inflated cost and pricing data, particularly during contract negotiations or when submitting certified cost or pricing data. If the government believes it didn't receive accurate, current, or complete pricing information, that itself can turn into an FCA matter down the road. Second, billing for substandard performance. That includes things like delivering goods or services that don't meet the contractual specifications, but they're invoiced as though they do meet those specifications. And third, contract compliant representations. And Jackie also touched on this. Certifications about compliance with testing requirements, sourcing requirements is a big one, cybersecurity standards, small business status, and other contractual conditions. Those can all become a predicate for a False Claims Act investigation and case. So referencing some of the examples that are up on the slide, Raytheon paid $428 million to resolve allegations involving false cost and pricing data during DoD contract negotiations and double billing under an existing contract. That case underscores how negotiation stage representations can become FCA exposure several years after the fact. DynCorp paid $21 million over allegations involving excessive and unsubstantiated indirect rates that were passed through to the Department of State. That's a reminder that rate support and cost allowability remain core enforcement areas. And DRI Relays paid $15.7 million after allegedly failing to conduct required product testing while invoicing for equipment represented as meeting military grade standards. That's a classic example of billing for non-conforming performance. I think the common thread for all of these is not necessarily any outright fraud, at least in the traditional sense, but it's really about the integrity and the veracity of the representations. Representations about pricing, about performance, about testing, and about compliance. For 2026, contractors should assume that any certification or invoice submitted to the government will later be scrutinized through an FCA lens. That question isn't just whether the work was done anymore. It's whether the documentation and representations align with what was contractually required. So I want to connect some of these enforcement examples directly to what internal audit and compliance teams should be prioritizing heading into 2026. When it comes to procurement integrity, from an audit perspective, this should mean reviewing certified cost and pricing data submissions, testing whether disclosures were current, accurate, and complete at the time of negotiation, examining controls around rate updates and post-award adjustments. For excessive and unsupported rate matters, internal audit should be stress testing things like support behind provisional billing rates, subcontractor and pass-through rate validations, documentation supporting cost allocation, and the reasonableness. And for representation and certification matters, that means auditing whether required testing protocols are actually performed and documenting. That second part is critically important, and documenting. Whether product or service certifications match underlying records, whether quality control teams and billing teams are aligned. You know, across all of these examples, the pattern is the same, which is FCA risk often arises not from catastrophic misconduct, and it certainly can arise in those circumstances, but more typically it arises from breakdowns between operations, finance, and compliance. So in 2026, audit plans need to prioritize areas where certifications are made to the government, technical requirements can be complex and complicated, and billing relies on upstream operational inputs. The key question isn't just, are we complying? It's, if DOJ looked at this 3 or 5 years or longer down the road, would our documentation tell a clear and defensible story? And that's really important mindset to take away to minimize FCA risk exposure. Next slide.
I think we jumped ahead. Can we go back the slide? Cybersecurity. Before I jump into this, I wanted to touch on a couple other areas that are related to the procurement fraud that we are expecting additional enforcement in that area. So one of those, there's a proposed rule that came out on organizational conflicts of interest to update the rules around OCI requirements. And part of those requirements of what's proposed are to include in solicitations and contracts in the future for OCI requirements and contractor disclosure requirements about potential OCIs that they might have, as well as affirmative representations about the disclosures that they're making and the accuracy of those. So we're expecting that if those requirements stay in the final rule that eventually comes out, again, it's over a year and the final rule has not come out yet, but when it eventually does, if those requirements are in there, then we would expect to see more FCA enforcement and potential liability related to false representations about the disclosures related to OCI. So that's something to just keep in mind as you're paying attention to the new OCI rule that's going to come out. Another area related to procurement fraud where we may see or expect to see more FCA enforcement is around contractors' use of AI, artificial intelligence. I think there's a number of different areas where there could be liability under the False Claims Act related to AI use. Contractors who falsely represent their capabilities, accuracy, or security of their AI models in their proposals or contract performance, they could face FCA liability. So if you're proposing to use AI and it doesn't live up to what you say, that could be a problem. There could be reckless disregard also for failing to check and analyze the work of AI, depending on how you might be using it in your business. So for instance, in the healthcare context, medical providers are already coming under scrutiny for using AI to suggest diagnostic codes that are later determined to be improper, like in terms of medical necessity in other areas, but also by failing to follow suggestions of AI when it encouraged revisiting prior diagnoses. For instance, if the diagnoses lead to higher billing to the government and AI would suggest that they actually use codes that would lead to lower billing, then they scrutiny for ignoring those suggestions from AI. So it's kind of a double-edged sword. So it's really important, as you know, AI is becoming part of everything that we do, that contractors be really careful with it, ensure that AI output is reviewed for accuracy, maintain records of AI policies, and oversight to demonstrate good faith attempts to remain compliant. And then one other area that is tangential to procurement integrity as well is antitrust, and specifically the procurement collusion strike force remains really active. So the strike force was announced in 2019. It's an interagency team that's made up of prosecutors from DOJ's antitrust division, as well as U.S. attorneys' offices across the country, and investigators from FBI, DOD, and other OIG offices. And the point of the strike force is to detect, investigate, and prosecute antitrust crimes which undermine competition. So they're really focused on bid rigging, price fixing, and customer or market allocation. And so this is really antitrust focused. Antitrust violations on their own are not necessarily False Claims Act violations. There needs to be that false claim that's submitted. You have to meet the FCA elements, but it is possible, absolutely possible, that antitrust actions can support FCA liability. And so the investigations and the work that the procurement collusion strike force is doing is leading to FCA liability and settlements as well. DOJ has reported that at the end of fiscal year 2025, they have trained over 46,000 agents and procurement officials on how to better detect and deter antitrust crimes. This is wide-ranging across the government to try to deter this type of action. There have been over 195 investigations opened, over 75 guilty pleas and trial convictions, and DOJ has recovered over $70 million in fines and restitution. So it's really, again, very critical to pay attention to who are you talking to, what agreements are you agreeing to, could it be viewed as antitrust violations when you are preparing your bids, when you're thinking about your team arrangements. There can sometimes be a fine line about what's permissible and not permissible in terms of exclusive teaming. And careful with who you're talking about in terms of pricing in your proposals. So just be aware of the procurement collusion strike force is out there and very active. So with that, now I'll jump into the slide that we have here, the next key enforcement area being cybersecurity. So there's been a heavy focus on cybersecurity noncompliance as a basis for FCA liability for several years now, and we expect that to continue increasing. That's not going away. In October of 2021, DOJ created a civil cyber fraud initiative to pursue cybersecurity related fraud by government contractors and grant recipients. So this sort of FCA exposure here stems not necessarily from a cybersecurity breach on its own, but from contractors certifying compliance with cybersecurity requirements when they're not actually compliant, or if they, for instance, might report inaccurate security scores. So the initiative here that was announced, they have had their first few settlements in 2022 and 2023, where contractors falsely represented compliance with cybersecurity requirements in their contracts. And the initiative continues to pick up steam, with settlements tripling over the past 2 years, and DOJ recovering $52 million in 9 settlements just in fiscal year 2025. So we're really seeing a big increase there. So for instance, I've got a couple examples here. HealthNet Federal Services and its corporate parent Centene Corporation agreed to pay just over $11 million to resolve allegations that they falsely certified compliance with cybersecurity requirements to timely scan for known vulnerabilities and remedy security flaws. And that in addition, it ignored reports from third-party security auditors and its own internal audit department as well of cybersecurity risks. So again, it's not necessarily about a breach, but about not being compliant with the contract requirements, and then that kind of deliberate indifference. They've been put on notice that they have vulnerabilities and cybersecurity risks, but they're ignoring that and not taking action at that point. That becomes a problem. Another example that we have here is that Morse Corp agreed to pay $4.6 million to resolve allegations that it failed to comply with contractual cybersecurity requirements by doing a few different things, including using a third-party company to host emails without ensuring that the third party met the contract security requirements, so they didn't have sufficient overview there. They failed to implement all required cybersecurity controls. They lacked a system security plan for its covered information systems, and there were allegations of submitting an inaccurate score for its implementation of required security controls and failing to update the score or notify the government after a third-party cybersecurity consultant notified the company that its score was wrong. So again, a lot of it is based on, once you are aware of an issue, what are you doing about it? Are you ignoring it, or are you taking steps to try to fix the problem? So contractors need to stay on top of cybersecurity requirements in their contracts and review their internal policies to ensure that they remain in compliance and fix any issues that are brought to their attention. This is going to continue to be very important, as I've said, especially with CMMC now in effect. CMMC clauses started being incorporated into DoD solicitations and contracts in November 2025. Contractors under those clauses will have to affirm their level of compliance with CMMC. So seeking payment despite misrepresentations or a failure to comply with CMMC requirements could be a basis for FCA liability. So that's another area. It's really important to pay attention to whether those clauses are in your contracts and understand what they require so that you're not misrepresenting whether you're in compliance there or not. And we can go to the next slide, and I'll turn it back over to Todd.
Thanks, Jackie. So we're still talking about the pandemic. Even though the public health emergency has ended, pandemic-related enforcement remains very active. To date, there have been more than 200 settlements totaling over $230 million, specifically tied to pandemic-related fraud matters. More than $820 million has been recovered for improper payments or fraud involving pandemic relief programs more broadly. So while the initial wave of enforcement focused on obvious fraud schemes, we're now seeing a second phase, and that's more document-based cases. A recurring issue is incomplete and inconsistent documentation supporting eligibility, the use of funds, certifications regarding how those funds were used, payroll calculations, and certainly forgiveness applications. We're also seeing continued clawback efforts involving the Shuttered Venue Operators Grant and the Restaurant Revitalization Fund. As some of you likely remember, these programs distributed funds quickly, and agencies are now revisiting eligibility determinations and certifications with far more scrutiny. The Small Business Administration in particular has significantly increased oversight and audit activity. That heightened scrutiny is likely going to translate into additional FCA investigations heading into 2026, especially where the certifications were made under time pressure and internal controls were less mature, to be charitable about it. The key risk here is not necessarily intentional fraud. It's really the certification risk. If documentation doesn't clearly support eligibility representations made at the time of application or forgiveness, that can become the foundation of an FCA recovery years later. For contractors and grant recipients, it is a good time to reassess document retention, reconcile certifications against supporting records, and evaluate exposure before the government does. Pandemic enforcement is not winding down. It's maturing into document-driven cases. Do the next slide.
Okay, our next area where we see enforcement for 2026 and beyond is trade, tariffs, and customs. So FCA enforcement in this area is significantly increasing, which isn't surprising in light of the broad tariffs that have been imposed on imported goods over the past year, and that continue to be imposed. Enforcement in this area generally stems from companies that misclassify products, misrepresent the country of origin of imported goods, and otherwise disguise the goods to avoid evade paying duties applicable to those goods. This is like the reverse false claim situation that I talked about, where money is being held that is owed to the government, but is not being paid to the government. So as an example here, this type of false claim, there's a DOJ reported a $54.4 million settlement, which it described as the largest customs fraud resolution ever under the False Claims Act. This involved allegations that from 2020 to 2024, Seratovit knew its products were made in China and transshipped them to Taiwan before they then went to the US from Taiwan. And the contractor or importer misrepresented that the country of origin of those products was Taiwan rather than China to avoid paying applicable tariffs there. So we expect increased enforcement in this area as DOJ launched a trade fraud task force in collaboration with DHS and specifically Customs in August of 2025, with a goal of strengthening coordination and increasing enforcement against parties that attempt to evade tariffs or duties or import prohibited goods into the US. DOJ's press release announcing the task force stated that it will aggressively pursue violations using the various enforcement mechanisms available to it, specifically including the FCA. That press release also encourages whistleblowers to initiate key TAM actions or submit referrals through DOJ's corporate whistleblower program. So this is an area where parties in the supply chain that are aware of improper classification of products can become relators, whistleblowers, and trigger key TAM cases. Even though SCOTUS recently invalidated certain tariffs that President Trump had imposed, the president is imposing tariffs under other avenues that he has available. So tariff evasion and resulting FCA enforcement still remains in the crosshairs. This is going to be an area that the government prioritizes. So for importers and supply chain heavy contractors, it's important that they validate the customs classifications, origin documentation, and duty calculations, and retain documentary evidence of their compliance. And where there's reliance on suppliers, make sure that you are getting representation certifications from your suppliers, and do the due diligence you can to know that you are able to rely on those. And we can go to the next slide.
So diversity, equity, and inclusion programs as an enforcement priority. So in January of this year, President Trump signed Executive Order 14173, and that order directed federal agencies to combat what it describes as illegal private sector diversity, equity, and inclusion preferences, mandates, policies, programs, and activities. Federal contracts and grants now require certifications from recipients that they do not operate what are described as illegal DEI programs. And the Trump administration has made this a key enforcement priority. And they intend to use the False Claims Act as a vehicle for that enforcement initiative. In May of 2025, the Department of Justice launched the Civil Rights Fraud Initiative, which specifically targets DEI policies and issues around anti-Semitism. And in December of 2025, the DOJ issued civil investigative demands, essentially formal document requests, to a number of large private sector companies that are suspected of violating these rules. To date, it's important to note that courts have been skeptical about the use of the FCA as a mechanism to enforce discrimination claims, especially in these emerging areas. For contractors and grant recipients, this doesn't mean you should carefully evaluate. You shouldn't carefully evaluate your DEI programs and policies. You need to understand the certifications that were made and how these certifications are tied to federal contracts and how they might expose or create exposure for FCA risk. It's important to stay abreast of these enforcement efforts as they evolve. We're certainly very active in this space, posting and publishing in this area. There's a tremendous amount of uncertainty, I can say, legal uncertainty regarding whether or not the FCA is an appropriate vehicle for enforcement. But it's certainly an issue and a space that we're intending to monitor closely into 2026. Next slide.
Okay, our last key enforcement issue is small business fraud. So we're continuing to see many False Claims Act investigations and lawsuits that stem from allegations related to small business fraud. These actions can take the form of misrepresentations of small business size or socioeconomic status, where those misrepresentations occur to get set-aside contracts. So for instance, a purported small business may not actually be small if the business has affiliates as defined under SBA's regulations, but it fails to account for its affiliates' revenues when it's calculating its size. Or it might lose its small business status after a merger or acquisition and not be tracking that, and then still representing in its proposals that it's a small business eligible for a set-aside contract. As an example here, there was a nearly $950,000 settlement with GS Foods to resolve allegations that the company improperly bid on contracts that were reserved for small businesses, despite not qualifying as a small business due to affiliation with other companies. Small business fraud can also arise when a company misrepresents its socioeconomic status, where it's not actually owned and controlled by the proper individual for that status. For example, a woman for a woman-owned small business, or a service-disabled veteran for an SDVOSB. So there might be a woman or a service-disabled veteran who owns and controls the business on paper, but they're really more of a figurehead and not really running the show. And that can lead to FCA liability as well. So DOJ is also focused on contract non-compliance as it relates to small business requirements, such as a failure to comply with the requirement that a small business prime contractor has in terms of self-performance, performing a certain percentage of the work itself versus subcontracting the work to non-similarly situated entities. So here, DOJ is concerned with the small business essentially acting as a sham or a pass-through entity where a large or otherwise ineligible business ends up doing the majority of the work and getting the associated payment. As an example for this type of situation, Sanford Federal and its owner agreed to pay just over $3 million to resolve allegations that they misrepresented Sanford's size to acquire small business set-asides and knowingly violated the limitations on subcontracting on an SDVOSB set-aside, so passing through more of that work than they were permitted to do as an SDVOSB. So in terms of what we're seeing with the government right now, there's a lot of hostility to the 8A program currently. In June 2025, DOJ announced that a U.S. aid official and 3 corporate executives pled guilty to a decade-long bribery scheme that resulted in $550 million in 8A awards going to companies controlled by those executives. This situation helped cement a belief among government officials that the 8A program is rife with fraud. And that has eventually led to SBA announcing in early December a full-scale audit of the 8A program to identify and weed out fraud, waste, and abuse. For that audit, every 8A contractor was required to submit detailed financial and performance data to SBA to validate their eligibility and compliance with performance work requirements. Since that time, over 1,000 8A firms have been suspended, although some have had the suspensions lifted. And SBA has also initiated termination proceedings for over 150 firms for allegedly failing to meet economic disadvantage requirements. Additionally, the Department of War is undertaking its own audit of all active 8A sole source contracts, 8A set-aside contracts, and small business set-aside contracts over $20 million to determine first whether the contracts are necessary for the Department of War's mission, which is war fighting, and also whether each contractor is complying with the limitations on subcontracting there. So these audits are really likely to result in FCA investigations and enforcement actions if there are misrepresentations and non-compliance that are found. So to avoid liability here, it's critical for small businesses to understand eligibility requirements, methods for calculating their size, and to also track their performance when acting as part of a team, whether as a prime or as a managing member of a joint venture, to ensure that they're meeting those performance of work and limitations on subcontracting requirements. Can we go to the next slide, please? Okay, so I wanted to briefly touch on The Administrative False Claims Act, this is separate from the Federal False Claims Act. It's an administrative way to go after false claims and misrepresentations. So this was actually enacted in December of 2024, and it previously existed as the Program Fraud Civil Remedies Act of 1986, but some important changes have been made to it since then to make it a more useful enforcement tool for agencies. The purpose that it serves is to enable administrative recovery of small dollar false claims, now up to $1 million, whereas prior to enactment, the original threshold was for false claims up to $150,000. So that increase allows agencies to administratively pursue recovery up to $1 million now. And this is for when DOJ declines to pursue an allegedly false statement. It largely parallels the False Claims Act, but it has some notable differences. The AFCA does not have a qui tam provision, so instead it relies on administrative adjudication, and it grants agencies subpoena authority to support their investigations. So no whistleblower aspect under the AFCA. The AFCA covers false written statements even without a claim. So there does not need to be that claim like we discussed earlier under the Federal False Claims Act. So that means an agency can rely upon a simple submission to the agency to form the basis of its enforcement action against a contractor. This could be like a submission for payment, a change order request, or any statement that seeks action by the agency. That can be a basis for the agency to go after this. Next slide, please. Okay, so some other differences from the False Claims Act are that under the AFCA, the maximum recovery is double damages instead of triple damages. There's a $5,000 penalty for each false claim, rather than that's lower than under the False Claims Act, where each claim had a penalty of roughly $14,000 to close to $29,000. The changes from the prior statute, now there's a 10-year max statute of limitations, so that now is in line with the False Claims Act. The agency does need DOJ approval to move forward with an administrative proceeding, but the agency leads it rather than DOJ taking the lead under the AFCA. These procedures are implemented through agency regulations, and it's kind of been a little bit of a slow process for different agencies to get them implemented. So we have listed here a few of the agencies that have already implemented AFCA regulations for their agencies to be able to use it. And then more recently, also DHS issued a final rule last November, and NASA just recently issued a proposed rule to implement the AFCA at the end of December of 2025. So we expect to see agencies relying on this more for those smaller claims. So just be aware, even in those situations, there's still the potential for liability. Next slide, please.
Okay, so we're not just seeing a growth in the number of qui tam cases and False Claims Act cases being brought, but we're seeing a growing constitutional debate around the qui tam mechanism itself. And that core issue centers on the Appointments Clause of Article 2 of the Constitution, which essentially requires individuals who are exercising significant federal authority that they be properly appointed as officers of the United States. When you have instances where private individuals, like a qui tam relator, bringing lawsuits on behalf of the United States, they are essentially litigating the United States position and seeking recovery for an injury to the government. They're not appointed, of course, under Article 2 by the president. And so several courts have, including our Supreme Court, have indicated at least a willingness or want to look at this issue a little more closely. There is a case that was originally decided in Florida. It's actually pending appeal in the 11th Circuit, which was just argued in December of this year, called the Zafirov case. It's up there on the slide. And in that case, the trial court held that the qui tam provision of the False Claims Act does violate the Constitution. The court reasoned that allowing a private individual to exercise executive power, specifically prosecuting claims in the name of the United States without an appropriate appointment under Article 2 raises serious constitutional concerns, and dismissed the qui tam action. That was heard by the 11th Circuit Court of Appeals, and I would be shocked if that case is not at least pursued to the Supreme Court. There's another case that we've called out for your attention. Wisconsin Bell Inc. v. United States ex rel Heath. In that case, members of the Supreme Court signaled their own potential interest in revisiting this issue. Justices Kavanaugh and Thomas expressed concern about whether the qui tam structure is consistent with constitutional requirements, including Article 2. And at least as far as they're concerned, indicated their willingness to give this issue further review. There are other districts where similar constitutional arguments have been raised, some with success, some with a lesser degree of success. But it's very much an issue that is on many practitioners' radars and many businesses' radars going into 2026. So what does this mean in practice? Well, the qui tam mechanism remains intact for now. Filings continue at record levels. We expect that trend line to continue. But if the Supreme Court were to take up the constitutional question and significantly narrow or invalidate that provision, it would fundamentally alter FCA enforcement, at least how we know it today. Since whistleblower initiated actions account for the majority of FCA recoveries, any shift in the constitutional landscape would have substantial enforcement and financial implications. For now, the risk environment certainly remains elevated, but this constitutional issue represents a potential inflection point that is worth monitoring, and so we will. More to come on that. Next slide.
Okay, the last area we want to talk about today is how to protect yourself from FCA liability and what you should do if you're dealing with an FCA matter. So how do you protect yourself? Ensure regulatory and contract compliance. Really important to actually know what the law requires and what your contracts require. So if you're an SDVOSB, for instance, owner of an SDVOSB, you need to understand what the requirements are to make that certification. Or you need to work with attorneys or industry experts who can help you understand what the requirements are for your contracts. Dedicate the time and resources to ensure compliance with all requirements, whether that is for cybersecurity, for invoicing properly, for domestic sourcing restrictions. Take the time to actually understand. We recommend creating written standard operating procedures and policies for how to handle these requirements, like how to handle invoicing, how to handle contract compliance. Assign specific duties to specific employees who are going to ensure contract compliance. And in best case, have multiple people so that there are checks and balances. So you're not relying on just one person who might slip up and end up costing the company millions of dollars. Create checklists and make sure that you are using them to ensure that you're following proper procedures. Use internal audit procedures, so make sure that what you're submitting is accurate. And it's not just enough to check at the beginning of performance that you're doing the right thing, you understand it then. You need to check regularly during performance to ensure that you're still compliant and see whether anything needs to be improved in your processes. And having contemporaneous documentation of your understanding of ambiguous requirements and showing efforts to understand ambiguous requirements is really helpful too. We recommend training. Employees need to understand what the requirements are, and also train managers so that they can help the employees understand what the requirements are. If you do get a complaint from an employee, take it seriously. Otherwise, you may end up facing a qui tam suit. You want to undertake a thorough evaluation to understand the allegations and determine whether there's any merit there. Document the investigation that you undertake and take steps to improve if there are failures, and document how you resolve the matter. That might be a mandatory or voluntary disclosures to the government. If there is a False Claims Act violation, you would have a mandatory disclosure requirement. You might want to improve your internal processes to ensure it doesn't happen again and have additional training. And then you want to have a contingency plan in place for what you'll do if you're faced with an FCA violation. So who will you reach out to for assistance, for example? So have that plan in place. And I'll turn it back over to Todd to wrap it up with the last couple slides.
Thanks, Jackie. And we're running down on time here, so I'll be quick. So, notice of an FCA case can come in different forms. A grand jury subpoena, which usually suggests that there might be a criminal investigation or criminal matter opened. A civil investigative demand, which is usually the more typical way. And that's a request from, it could be the Department of Justice, it could be the Office of the Inspector General for a various agency. And then a search warrant, which is probably the more unusual or extraordinary way to get notice of a false claims matter. I think the takeaway from the last two slides is if something ends up on your doorstep, first rule of thumb is don't panic. Obviously, these investigations are serious, but they are manageable with the right response. And part of the right response is having a plan in place. It's going through things like the audit that we talked about before. It's ensuring that you have appropriate documentation. It's ensuring that you have counsel who's experienced in these matters available to you assist you with sort of first steps. When to talk to the government, who should be speaking with the government, what should they be saying, how much to cooperate with the government at the appropriate time. Timing is somewhat significant for a variety of reasons. And so you do want to have capable counsel on board. You don't want to panic because, chaos it's never productive or efficient for sure. So you want to have a plan in place. And part of that plan very much encompasses the things that Jackie and I spoke about here, and having, counsel in real time sort of walk you through that process. The last slide, please. So if and when the circumstances arise, you want to do what you can to preserve and control information. That means preserving documents. We've talked about engaging knowledgeable counsel. You want to have a privilege protocol in place to govern the investigation, preserve appropriate documents, and counsel not only assists with the privilege considerations, but really with understanding the factual landscape, understanding the scope and exposure, assessing potential damages, evaluating whether the allegations have merit. And that investigation really does need to be controlled. It needs to be documented, and it does need to be strategically sequenced. You'll want to have counsel on board to discuss what an appropriate disclosure and cooperation strategy may be. Every FCA case is a little bit different. There are benefits to cooperation in certain circumstances. It can provide mitigation, but there are other instances where mitigation is not may not be the right reaction to a key TM action that we suspect has been filed. So all of these things need to be considered and vetted through counsel. And since we've run long, I will wrap it up there.
All right. Thank you, everybody, for joining us today. I hope you have learned a little bit about the False Claims Act and the areas where we anticipate more enforcement over the coming year. You got our contact information there. So if you have any questions, please feel free to reach out to us. We appreciate you joining us today.